How do shareholders in a minority position defend their interests? Welcome to another episode of the Whole Law series. Learn about minority shareholder protection in English law and prepare for your law exams and the SQE. This podcast was prepared by Dr. Ioannis and is narrated by him. Have a look around the linked playlist for more podcasts on key English law topics.
The company directors are the people who run the show, but because they're the people who run the show, they're also the people who can get stuff done in an inadequate fashion and lose the company money. So that clearly leaves a lot of people pissed off because they're losing money. So when we talked about directors' duties and the way in which directors' duties are expressed, we came across a whole range of things that inform our understanding of how a company could be properly run and make money for its shareholders. That is the primary objective, right? Make money for the shareholders. So the directors' duties came out broad categories, one of which was, what are the rights that they've got, the obligations, how do they carry them out, but also quite a lot of information about conflicts of interest. And what happens if you're a decision maker, but you're pulled in two different directions, and how do you make decisions, how to address those? What was the primary way in which we were dealing with conflicts of interest? Disclosure. Either an individual director is involved somehow in something that is the company's business, and then they need to disclose that problem to the rest of the directors and ask for permission to carry on, or maybe the board as a whole is affected, so then they need to disclose this to the shareholders. There are actually some cases where an individual director could be the one affected, but what's going on is so serious that needs approval by the totality of the company, including the shareholders. And that's how you get away with this problem of having difficulty making up your mind when you're trying to serve both a personal interest and something that is supposed to be the interest of the company. Now, all of these things go wrong in a variety of ways, but we're left with the issue, and this is where we're coming into today. If something has gone wrong, and we know that the company can then pursue the directors for having lost money and to correct the mistakes that they made and all the rest of it. But it just leaves us with this problem that if the directors are the people who are running the show, because the company is not in a position to make decisions by itself, it is a virtual entity. If the bosses are the ones doing things wrong, who is going to take the initiative to defend the company's interests? The company can only speak through the board of directors, but it is the board of directors that are messing things up. They're unlikely to have an epiphany and blame themselves. So if the totality of the board is involved in some sort of misbehavior, they're clearly not going to call themselves out. If one of the directors is involved in some misbehavior and he's in the minority in the board, it is possible that there are enough independent directors that will take some action. Do you remember what we were saying about non-executive directors? So who is a non-executive director? What are they supposed to do? The non-executive directors are precisely people who are not involved in the kind of day-to-day stuff, but they have a degree of independence from the people who actually operationalize everything that needs to happen for the company. So if you have a bigger structure where you have a group of people with executive functions and people that are non-executive, you would hope that if one of the directors or perhaps a few of them do something wrong in their executive function, the people who are non-executives who see this, they're going to go, hey, hang on a second, what is this? And then they're going to motivate the company to pursue the directors to correct whatever has gone wrong. But if it's a smaller structure and they're all in on it, or the director who's misbehaving is then supported by the others because they're friends or they're very closely linked, or it's one of these situations where they cover each other's backs when they do something wrong, then we have a situation. So it's great to say that the company is an independent entity with independent decision-making capabilities and all the rest of it, and this is carried out by the board of directors. But if the board itself is malfunctioning, there's nobody left to act on behalf of the company. Perhaps AI will be a solution. Do you guys have problems with the concept that AI might be given personality and might be recognized as like a person with its own initiative and rights and obligations and all that stuff? It's not like we don't have examples of this happening in the law, because corporations are the example. Because you're having all these debates in the press, that AI is going to reach a point of independence in its behavior that we might have to recognize it as a person. And everybody's like, oh, that's crazy. That stuff cannot happen. But we do recognize corporations. That's the whole point of these classes, right? We do recognize corporations who are virtual entities as having separate legal personality and having rights and obligations. I mean, to an extent, we recognize rights on animals as well. We certainly do, even though, so they have like independent behavior, but they don't have decision-making capability, right? But we still recognize rights and we try to protect those rights. If you look at it from that perspective and you're not thinking about the ethical implications, but you're thinking about the practicalities of using the law to recognize personality in artificial constructs, I think there's a good parallel between corporate law, like companies are artificial constructs, and AI as a sort of artificial entity that might attain legal personality. Maybe in a few years' time, when this class re-emerges from the ashes like a phoenix and establishes itself as an independent module yet again, we'll be able to talk about companies represented by AI that actually run themselves. It's going to be awesome. So that way we don't have to do anything. We can sit at home and starve to death. Right. Okay, that aside, I think everybody appreciates the problem. If the artificial entity that's the corporation can only act through the agency of its directors, if the problem's coming from the directors, we need somebody else to take charge. So who is this somebody else? So we're starting this discussion by trying to see what mechanisms exist in the law that will allow other people who are not the directors to step in and defend the company's interests. By the way, if we need a quick reminder for context of what were the duties of the directors, right? The key obligation of the directors is to act within their powers, which is in 171 of the Companies Act 2006. Then they're obligated to promote the success of the company. What this means in practice is make money for the shareholders. They are supposed to exercise independent judgment, meaning that they cannot subcontract their decision-making to somebody else who is external and then say, well, it wasn't me, it was somebody else. They're obligated to exercise a reasonable care, skill, and diligence when they're making decisions. Incompetence will eventually lead to trouble because it will be perceived as a breach of directors' duties. They've got what we already talked about, the duty to avoid conflicts of interest. So when they're acting in company business, they're supposed to be 100% focused on the success of the company. If there's other objectives, especially of a personal nature, that they're trying to achieve, then we have a problem, and this will be perceived a conflict. They're not allowed to accept benefits from third parties, and they're under a duty to declare interests in anything that is forward-coming if, again, it raises a conflict of interest. So the directors are supposed to do all these things. How do we know that this can be achieved when the board itself is the source of the problem, but the board is not calling itself into account to defend company interests? This came up in the courts very early on. Because as you can imagine, ever since the idea of a modern corporation was established in the Victorian era, at like the beginnings of the 19th century, we started to come up these problems that stem from agency relationships. In every agency relationship, as you may have come across in commercial law or related subjects, aligning the interests of the agent and the principal is always a problem. How do you ensure that somebody is working for the benefit of whomever hired them and is not working for themselves? This came up in the courts in the most notable way in the case of Foss and Harbottle. This is an old case, like from 1843 already. And the scenario there is typical. You've got the bosses behaving in a way that harms company interests. And the key point here is that their behavior is not disadvantaging a specific shareholder, but their behavior is detrimental to the company's business as a whole. And making this distinction early on is important, and this will have consequences going down the line. So the court in Foss and Harbottle sits down and tries to think about this. how can we defend corporate interests when the complaining party is not the board of directors? What right do we allow external people, like a shareholder who has noticed that something goes wrong? What right do we allow them to come to the court and complain on behalf of the corporation? Again, this is something that's important. They're not complaining for themselves. They're complaining on behalf of the corporation. The court says there are a few fundamental rules here. One of them is that the directors are the bosses. So the management of the corporation takes place by the directors. And the second one is, that kind of flows from this, is that the proper plaintiff, so the proper person to complain for something having gone wrong with the company, is the company itself. Therefore, accepting the complaints of a third party, for instance, one of the shareholders, can only be accepted as an exception to these rules. Again, fundamental rules. The bosses are the directors, they're the ones running the company. And secondly, the right person to sue on behalf of the company is the company itself. So anything else, anybody else who takes the initiative needs to be as an exception to these fundamental principles. What does this mean in practice? It means that shareholders should not assume they have the right to go and complain if they think something's going wrong. They have no independent standing to go to the court. Now, you guys are probably familiar with concepts like the doctrine of privity and all the rest. Does anybody remember what that is? So for instance, when you were doing contract law, what is the doctrine of privity? She hires you to edit her Instagram posts, and you do a terrible job. And I've seen those Instagram posts. I'm thinking, this is a disgrace. It's like an affront to culture and social media. And I would like to sue you for having done such a terrible job on your contract with your colleague there. Can I do that? No, I don't have standing. That's the doctrine of privity, right? Privity means that you have rights and obligations arising from contracts if you're a party to that contract. How do we figure out if you're a party to that contract? You have provided consideration. I, may legitimately be offended by the terrible job that you've done, but I really cannot sue you on your contract. It needs to be your contracting party. Similarly, for a corporation, the person that's in that deal is the corporation itself. So we need an exception that allows a third party to get involved. To take back the example from contract law, the exception to the doctrine of privity is that you've got a third party that's supposed to benefit from the contract, and the contract has given them that capability of being involved in enforcing the contract. So if she hired you to edit my Instagram posts, so I'm the beneficiary third party, and my rights to respond are not excluded in your contract, then I would have the right to sue you. But that would be an exception to the normal rule. Now, the exception that the court came up in the case of Foss and Harbottle is called fraud on the minority. If the directors are not simply doing a bad job, but they are actually trying to harm the shareholders to the level that the court, you should read the case because it's interesting, but the gist of it is, if what is happening is effectively trying to defraud the shareholders for the private benefit of the directors, then that creates an exception to this rule because it demonstrates that the company is now dysfunctional, that the board cannot be trusted to take independent action to protect the company's interests. So as an exception, the court will give the right to a third party, in this context would be the shareholder, to sue on behalf of the corporation. So the court would recognize a shareholder as the initiator of an action on behalf of the company. So nowhere at this discussion are we saying that the victim is the shareholder. The victim of whatever has gone wrong is the company. But we just need somebody to initiate the action to defend those company interests. So once the court accepts that fraud on the minority has taken place and accepts standing for the shareholder, then the action is not personal to the shareholder, but becomes an action of the corporation. So the court basically passes on this action to the corporation, and then the corporation is the beneficiary if they win, but is also responsible for costs and all the rest of it. So the shareholder is not going to have to pay for the trial by themselves. The corporation takes care of all of this stuff because from that point onwards that the court has taken it on, it becomes a corporate action. Does this sound like a good solution to this problem? Why not? I mean, actually, it's the only solution to this problem because you cannot, I mean, in this context, I'm referring to shareholders as a third party in relation to the action. But in fact, the only people inside this problem are the directors and the shareholders. Because technically, the directors and the shareholders are the people who are inside the corporation. Everybody else who might be affected, we were discussing, is called a stakeholder, who has sort of legitimate business with the company and is affected by its behavior, but does not affect decision-making. The only people who affect decision-making, fortunately or unfortunately, are the directors and the shareholders. So if you don't recognize the shareholders as having standing to bring an action when something goes wrong, you got nobody. I mean, it would be a lot more difficult to recognize a truly external party, like an external investor, a bank that gives a loan or somebody, as having the capability to defend the company's own interests. So from a theoretical point of view, there's nothing wrong with this. It makes perfect sense. Technically, though, it's a bit tricky. Because to say the rule is proper plaintiff, the rule is management by the directors and all the rest of it sounds grand, and to call everything else an exception also sounds grand, but if you don't have exact criteria how to benefit from this exception to bring an action, then you run into trouble. And they did run into trouble. So if you look at case law that comes after this, so you see cases like Edwards and Halliwell from 1950. You see we've got some cases before Foss and Harbottle. But if you want to look at more modern interpretations of these rules in Wallerstein and Moyer from 1975, we do have a continuing problem in trying to figure out what needs to happen for something to come within this exception of fraud on the minority. What is usually the conclusion of the common law being inconsistent? So if we can't figure out what's going on through the cases, what usually happens? The government legislates. So if there's a problem and the courts are struggling to arrive at a kind of workable solution, then that usually prompts legislative intervention. That's why we have a parliament. Okay? The parliament is not just to elect our mates as MPs, give them a salary and expenses, and have them going on trips. They're supposed to be there to respond to needs to amend and improve legislation. So what happened there, because the criteria for using this exception, which comes under the broad heading of derivative action, because the courts couldn't get to a point that we had consistent application of those rules or even a secure understanding of what the criteria are, then there was legislation to put this into a legislative setting. Now, as you probably know, but I think it's worth mentioning again, we are looking at case law before and after a legislative intervention. Because obviously, case law after is relevant because it shows us how the courts are interpreting the new rules. But since the problem is common and is consistent historically, looking at case law before what happened is helping us understand, or is helping us create arguments that we could use in court. So there's solid reasons to look at case law before and after a specific act of parliament, and it informs your understanding. Now, in practical terms, if you were addressing an essay question that says, derivative actions have been a mess, and assess the extent to which the Companies Act 2006 has improved the situation, then you have to look at the law the way it was before and then the way it evolved. Otherwise, you wouldn't be able to have a meaningful discussion. If you're answering a problem question, there is less emphasis in the law as it used to be historically, because in a problem question, you're trying to find a solution to a current problem right now. So what you're interested in is the law as is applied right now. So in a problem question, you would be looking at prior case law to help you understand what's going on, to give you arguments that you could present to the court and all of that stuff, right? But it's not obligatory when you're answering a problem question to go through a sort of historical evaluation of what the law was about. So if you were answering an essay question in the area of derivative actions, you inevitably need to discuss Foss and Harbottle and the reasons why the case law that stems from this is not terrifically satisfactory. But if you were answering a problem question, I would start from the statutory impression of those rules and then apply it to the facts as you've got them now to try and give a real life solution to the problem that you're presented with. And if the case is like super complicated and you need to draw arguments to convince the court about something that's not that obvious, then I would look kind of case law that has developed before and after the act. Where is this in the Companies Act? So this is beautifully located in the Companies Act in section 260. That gives us this statutory impression of what are derivative duties and how we're supposed to do them. So it says here that a member of the company can initiate an action. Now, this needs to be something that the company itself would be able to complain about. No, we're not complaining about random stuff. We're complaining about something that would be a violation. That if the board of directors was independent enough or competent enough, they would be pursuing for themselves. So we have a valid, live cause of action. And the purpose of this is to seek relief on behalf of the company. So the shareholder is not complaining that their personal position is being disadvantaged. They're complaining that the position of all the shareholders in their totality is being disadvantaged. You can only do this about something that the directors are actually doing, so you cannot use this complaint in a prospective sense, being like, oh, I don't like the directors, maybe I can get rid of them by initiating this. This isn't it. It needs to link to something specific. And it's subjected to a specific test as to whether this is in the company's interests. Now, this isn't a free pass to the court every time you have a pissed off shareholder. You need to identify a real problem that has a consequence for the company. If you remember back to previous presentations about directors' duties and the effects of their violation, it's quite possible that the directors are breaching their duties, but this does not cause financial harm to the company. Can anybody think of an example? It could be that the Articles of Association say that the directors are not allowed to make investments without the consent of the board or the consent of the shareholders if the amount exceeds £100,000. A director goes and invests £200,000. And then they make £1 million profit because it was a great investment. So this is a violation because they breached they did not stay within their powers. You remember this was one of the fundamental rights, 171, act within the powers. They have acted in violation of their powers, but this didn't actually cause financial damage to the company. So what would be the point of suing? Because they actually made money. So you don't have a live cause of action that can promote the company's interests, even though nobody doubts that there's been a violation. So if you're in that situation and the shareholders are really pissed that the directors are not respecting their boundaries and they're doing whatever they want, what should be the appropriate thing to do for the shareholders? So as a group, the shareholders are thinking these guys do whatever they want, whenever they want it, and when we complain, they go, well, we made money anyway, what are you complaining about? So what could the shareholders do? They can get rid of them, because the problem with saying holding them accountable is you could hold them accountable and then ask them to repair whatever damage they've done, but if they've actually made money for the company, there's no damage to compensate. Yeah. So one way, if the shareholders decide that they don't approve of this behavior, one of the things that they can do is to dismiss the directors. If the shareholders are unhappy with the board and they want new directors, they can dismiss the existing directors. The mechanism is in Section 168 of the Companies Act of 2006, and it requires an ordinary majority. So if more than half the shareholders are unhappy with the directors, they can get rid of them and then they can appoint somebody new. But what they shouldn't do, and actually they're not allowed to do, is to bring a derivative action, so drag the company to court to complain about something that has not caused any damage. So the criteria in 260 is you're complaining about something done to the company, but by pursuing this action, you're also trying to get something that is beneficial for the company. This isn't simply a mechanism to express dissatisfaction. So if somebody is trying to correct something that the directors have done and achieve compensation for the corporation because the company has suffered loss out of the wrong thing that the directors have done, then the way to do this is to use Section 260 to petition the court for a derivative action. The court will accept this to proceed if there's in fact money to be made. And I'm guessing if the amount is minor and it doesn't even cover the cost of the trial, that an action would be damaging for the company. It doesn't create great press. So you need to be able to get back something that is substantial, right? In that case, the court will approve it. The court will say no if you don't have a significant interest, so there's no significant compensation coming, and the court will also say no if the initiator of the action is trying to protect something that's very personal to them, that bothers them, but does not affect the rest of the shareholders. There's another mechanism that we're going to talk about in the next presentation about dealing with something that affects you personally as an individual. But this isn't it. The derivative action is to defend the interests of the company as a whole, the totality of the shareholders. How do you actually practically approach this if it comes up in a real-life scenario? You will need to identify what has gone wrong. So to be able to address these issues about correcting wrongs that have been done to the company, and this comes under a bigger label that's called minority shareholder protection, perhaps for the reason that it's usually the majority either in the board or the other shareholders that are sort of ganging up and carrying out something inappropriate. So you might see these discussions under a heading that says minority shareholder protection. The initial point that the trouble is coming from is going to be some breach of directors' duties. Because again, remember, it's not appropriate to go and complain that the directors are not doing the jobs every time the company loses money. Sometimes companies make money, sometimes they lose money. It doesn't suggest that somebody has done something wrong. Business decisions have got beneficial or can have detrimental consequences. Sometimes the environment changes and it's outside anybody's control. Sometimes the best thing to do right now turns out to be the wrong thing, but you couldn't have guessed when you were making that decision. Yeah? So I don't want to create the impression that any of those tools are mechanisms to complain when the company has lost money. They're a mechanism to complain when the company has lost money arising by some sort of violation. Therefore, to be able to address these topics, you need to have a background understanding of directors' duties, because this is where the violation is going to come from. So the starting point should always be, do we have a violation here, or are we simply complaining about having lost money? Losing money in itself is not an actionable thing. Losing money because somebody has done something wrong that they were prohibited from doing, that's an actionable thing. So you find the violation. You have to be sure that the violation has resulted in significant negative consequences for the corporation, because again, a violation that doesn't lose you money is nothing to complain about. So you got the violation, you got the loss, and you arrive at the decision. Can the company be convinced to pursue this? Can the shareholders at the general meeting have a declaration or something that requests the board to pursue a director who's been in breach? If that doesn't work, because they do this and the board of directors refuses and they don't have a valid reason for that refusal, are we then talking about the shareholders bringing this to the court on behalf of the corporation through the tool of a derivative action? And if that's happening in a real-life situation, then you have to advise them on the basis of the current law. So you would be starting from Section 260 of the Companies Act and then going from there to look at the facts and structure your argument. If it has not, if this is an essay-style question that is asking you to reflect on the evolution of the law, then you can start from Foss and Harbottle and just take us through the whole thing of what necessitated this change in the common law and then how it moved in its statutory impression and all the rest of it. The conclusion is going to be that if the court accepts to pursue with a derivative action, it then becomes an action from the corporation against whomever is at fault, and if they win, the director that has been at fault will have to compensate the company and possibly pay costs. If they don't win, then the company is burdened with those costs, but not the individual who initiated the action.
Having discussed derivative actions, now we are moving to the core of minority shareholder protection. Dr. Ioannis presents unfair prejudice petitions.
In any type of corporation, big ones and small ones, there should be no expectation that we've got an equal balance between the people who own the shares. It's very common that there is a majority shareholder and somebody comes in on a smaller investment. It could be that somebody wants to invest a little bit at the beginning and not to be fully invested, or somebody comes in a little bit later on and invests some additional money, brings in something in addition. But there's a weakness in being a minority shareholder. As with anything, nobody normally has a great time being in a minority, do they? I mean, the whole point of constitutional law and constitutional provisions and the whole point of law to begin with is to make sure that everybody benefits from the same treatment and has got like comparable rights and obligations. And this is even more important if you belong in a minority group and you're frightened that the majority might decide to do things that go against your interests. And if they decide to do this, there isn't much you can do about it. So there are mechanisms, or there should be, if there aren't, there are mechanisms there to protect people who are in a minority position in a corporation. How would you feel if I told you I am trying to branch out, I'm trying to raise more money, and I'm selling a 10% share in my company? So, my company is doing great. You're going to participate in the success of this company, and you can buy 10% of the shares. You don't have to do anything at all. As a shareholder, you don't have to do anything, right? I mean, you have the opportunity to participate in the general meeting and in certain types of decision making if you choose to do so. You're not obligated to do so. So I could offer you for 10% of my shares, you pay for those, you become a shareholder, you benefit in my success. When I pay out dividends, you get a nice chunk of this. It's a great deal. But there's one problem. It is a great deal, but if I decide to do stuff that are actually a terrible idea, you have very little influence over what I do. Voting at general meeting either takes place on a majority or a supermajority. Obviously, in order to change the Articles of Association, you need a supermajority because you're changing the kind of fundamental structure of the corporation. But look, if you're a 10% shareholder, I can take decisions on an ordinary majority on a daily basis if needed. I can change the Articles of Association because I also have a supermajority. I've got 75% of the shares and above. So I can actually do everything I want, and there's no way you can stop me. And if it's a private limited company, it's not even easy for you to get out. Because in a public corporation, especially for one listed in the stock market, if things don't go your way and you think the corporation is not performing up to your expectation, you just sell your shares and then the next person has to worry about it. But if you're in a private limited company, it's not easy to exit. It might be difficult to find somebody to sell the shares to. And it needs the consent of other people. It needs a change in the articles to be able to get out and all of that stuff. So it's going to be problematic. Therefore, we have an issue as to how to cater for the interests and make sure that people are committed, the people running the company are committed to benefiting everybody and not just the people in the majority. So it is still possible and within the law that a director is making decisions for the company that are beneficial to the company, broadly speaking, but could be detrimental to a particular shareholder. Can you think of an example of how a decision could be legal and beneficial to the company, but at the same time detrimental to individual shareholders? The company has good profitability, and instead of returning part of that benefit to the shareholders in the form of dividends, they choose to reinvest. This could be the right thing to do for the company, so the company can grow and become more successful in the future. But you're not going to be a happy bunny if first year you're in, you don't get any dividends. Second year you're in, you don't get any dividends. Third year you're in, you don't get any dividends. 20 years down the line, you don't get any dividends. So you've blocked your money into this investment, and you're not really getting anything out of it other than the promise of selling them at a better price in some indeterminate place in the future. If they are raising additional capital, they wouldn't be able to discriminate against existing shareholders. That might be a concern. You might be thinking, I understand my participation in the company on the basis of the existing shareholding. If they create lots of additional shares and I don't have the capacity to participate and purchase those additional shares, then gradually my position is getting diluted. So yeah, that could be another example of the company raising finance through additional shareholding, or perhaps the company taking in debt or doing something like this that might be good for the progression of the company, but might look like a dangerous or unpleasant thing for one of the current investors. So it's possible that the directors are taking decisions that are correct and appropriate, but individual people have a problem with them. When we're talking about minority shareholder protection, we're not talking about this. We're not talking about giving you like a free exit whenever you're unhappy, or giving you the rights to complain as an individual because this investment is not going in the way you wanted, or the direction of the company is not in the way you wanted. This is the way company law works. This is why you have a board of directors, and this is why they've got the ability to make decisions on behalf of the company and specific parameters within which they make those decisions. So this, you being unhappy for yourself, isn't a reason to complain. The whole discussion about minority shareholder protection is when in fact something's going wrong. The directors are disrespecting their boundaries, or they're taking decisions that are bad for the company, or they're taking decisions that benefit specific members of the company to the exclusion of everybody else, and they're doing this on purpose. That's the thing that we're focusing on. As we've seen previously, one avenue of reacting to this, if you are a shareholder, you're part of the general meeting, but you're not the director yourself. One avenue of reacting to management doing the wrong stuff is to bring a derivative action. But that is an action that defends the company's interests against misbehavior from the board. If you have a situation where there is a group of directors that take very, very bad business decisions, then you might be thinking as a shareholder, is there anything I can do to stop them? Or if they've done the thing already and the thing has caused damage to the company, is there any way that the company can recoup money from those directors because they've done something wrong? At which point you need to consider, is the wrong thing wrong in a business sense, or is it the wrong thing in a legal sense? For it to be wrong in a legal sense, it needs to be a breach of director's duties. And it needs to be a breach that causes harm to the company. The company itself is not willing to do anything about this. So then it falls to you as an individual shareholder to bring an action on behalf of the company and try and convince the court that the company has a cause of action against these people and it should be pursued and it will have a beneficial outcome if they're successful. Section 260 gives a statutory right to shareholders to appeal to the court to get permission to pursue an action on behalf of the company. And if the court thinks that it would be in the interest of the company to pursue this action, meaning there's some initial evidence that some violation has taken place and there's some initial evidence that some loss has been suffered, then the court will allow the action to proceed. Which is great, right? So we've got some things that can offer some protection to people who are not in a commanding position. I mean, you could argue that the fact that we've got different weighting for decisions at general meeting is some protection by itself. So if you need 50% for an ordinary resolution and 75 for an enhanced majority, then you ensure that with 75 you got enough volume of people who want to do something to make it a valuable thing to do. We were talking about ways in which somebody in a minority position that doesn't have a great degree of influence can do something. So one of the things that they could do is if they're not a tiny minority, maybe they've got more than like a quarter of the votes at general meeting. If you've got more than a quarter of the votes, then you can block special resolutions. So at least you can, if you're a minority but not a tiny minority, you've got some level of control in excluding changes to the Articles of Association. So there's something. Now, what else can you do? The key difficulty is disagreeing with what the majority is doing. Disagreeing with what the board of directors is doing is already quite limited. Because as we said, they're entitled on the basis of the law, on the basis of the Articles of Association, they're entitled to run the show. So if as a shareholder you disagree with what they do, you have limited room to express that disagreement. But if you disagree with what the other shareholders are doing, like the majority of the general meeting, then you're even in worse trouble. Could you go and say, I'm in a minority position, but I want to be protected from other people messing with me and to have this expressed in the articles somehow? Could you carve out specific protections within the Articles of Association for people who belong in a minority? If they're doing something nasty to you, and I'm going to get there in a moment, if they're trying to do something nasty to you, there are some mechanisms to protect you. But could you be kind of forward about this and say, I will join the company, I will only get 10% of the shares, but I want some protections built in the Articles of Association as I'm coming in that we agree now. People in a minority position, a different class of shares, then that is a contractual, if you want to call it that, because it's expressed in the Articles of Association, but it is a valid mechanism to give them an extra layer of protection. And having somebody belonging in a different class of shares, it doesn't necessarily mean they're getting a great deal, they're getting a worse deal. It just means they're getting a different deal than everybody else. So it is entirely possible that you've got somebody joining in a minority position and you don't give them ordinary shares, you give them a different class of shares. Then, if that's what happened, the rest of the company cannot change the rights that are attached to that class without the consent of the class. And if it's only one person that is the total majority of that class, it means that they're secure from changes to their entitlements, at least in the way that they're expressed in the Articles of Association. So if I want to contribute to this company because I want to participate in the financial success. I don't want to be involved in day-to-day management. I don't want to do anything. But because I'm giving in extra cash that the company wants, I want to be doubly rewarded. So we could say that I am putting this 10% of the 10% of shares that I'm buying for myself, they actually have double dividend entitlement. Or the dividend pays first at a higher amount than everybody else. And this is written in the Articles of Association. The company cannot change their minds about this. Because if they decide to pay dividends, then the distribution is preset. I'm going to get, if it said double for me, I'm going to get double. So whatever they gave as dividend per ordinary share, I'm getting twice that. They cannot prevent me from doing this without changing the rights of my class, and I'm not going to say yes because I'm not stupid. Or if I say, yes, it's part of a negotiated settlement, they give me something else. They're going to say, look, your class doesn't work for us. We're going to change the rights of your class. Everybody has ordinary shares, but we're going to double the amount of shares that you got, right? And that's your incentive for switching. Creating a separate class of shares is a terrific way to embed some protections for people who are in a minority position. There are some other stuff that you could do. For instance, there is the idea of entrenchment. This is in Section 22 of the Companies Act. You can make some provisions in the articles subject to change only by the complete agreement of the company. You can class any provision in the Articles of Association as something that requires a supermajority to change. So you could say this, like, there's a provision that says something, if you want to change that one, it's not like the rest of the articles. I want an enhanced majority. You could even say, I want 100% agreement of all the shareholders in order to change this. Now, that would mean that certain articles that have been entrenched can only be changed if absolutely everybody agrees. So if you're in a minority position, no matter how small a minority you are, unless you agree, they're not going to be able to change it. Weakness with this idea is that entrenchments can only happen at the point of the creation of the company. So you need to be there at the beginning. Or, alternatively, you need to get 100% of the shareholders to agree to entrenchment. But this is a little bit unlikely if you're joining the company at the later stage. One of the mechanisms that we've seen in the past as well would be an external contractual agreement between the shareholders, because you can always have shareholders' agreements that they say they're going to do things in a certain way. You remember what is the problem with shareholder agreements? No, it's not binding to the company and it's not binding to future shareholders. So if we sign a contract, the two of us, it's between the two of us. If other people come around, then you cannot say, because of the contract we have between us, other people have got rights and obligations. So if there is a shareholders agreement, it means that if somebody subject to this agreement changes their minds and they do something, they're going to be in breach of contract. So then you can sue them in damages for breach of contract. But if you got new members coming in, clearly they're not covered. So it is a way to kind of embed some rights, but not a terrific level of protection. So we have putting stuff in the Articles of Association, entrenching things in the Articles of Association with higher majorities, external shareholders agreements, splitting people into separate classes of shares. All of these are mechanisms that can give a greater degree of confidence to somebody in a minority position that they're not going to be messed about, but none of it is a complete agreement. The key issue that normally turns up in the courts in this area is people disagreeing with decisions of the majority. And it is a sad and painful area of company law that consistently generates new cases that go to the courts. Now, if you're wondering, well, if we got so much case law on it already, why do these things end up in the courts all the time? They end up in the courts because people are fighting over the facts. They're not fighting over what the law is. And that's why most things end up in the courts. It's not like we don't know what the law is and we want the judge to tell us. It's like we know what the law is, we just disagree what our rights and obligations are on the basis of the factual basis that we have. Now, the key problem that we've had is expropriation. What happens if the majority of the company decides to expropriate a minority? What happens if I've got this 10% shareholding and 90% of the shareholders say, we're going to change the articles to buy back those shares or buy you out? It's like, we don't want you out anymore, goodbye. So I'm getting kicked out. What am I going to do about this? Now, it might sound like this is an abusive thing to do. Why are you kicking out a minority? But the rule is, and you can see this in cases like Allen and Gold Reefs of Africa, it's a case from 1900. You got Brown and British Abrasive from 1919. You got Sidebottom and Kershaw from 1920. All these cases remind everybody that the company, as a unit, takes decisions for the benefit of the company, not for decisions of individual members. So if the company decides to expropriate a minority, if this is the right thing to do for the future of the company, it's going to be okay. I know that this sounds horrible, right? Doesn't it sound horrible? That they might take decisions to exclude you and kick you out, and there's nothing to do about this if the change is in the interest of the company. Can you think of a reason why it would be in the interest of the company? But you see, it can't be personally targeted, because if the majority thinks you're annoying, then that's not really deciding to kick you out because you're annoying. This seems to be like a kind of one-on-one personal thing, like a difficulty in the relationships, as opposed to an action that is in the interests of the company. So for something to be in the interests of the company, it has to be in some sort of reorganization context that's not personal. So you've been like a minor shareholder. We're having a new investor coming in that wants to buy 90% of the shares, or it's like in a merger scenario. So in that case, you might get kicked out because there's a major investor coming in that's got a different plan about how the shareholding is distributed. So it's not like we don't like you personally. It's like this is the right thing to do for the company going forward in the way they organize their finances and so on. So the court has said in all of these cases that what matters is that the interests of the company are behind the decisions that are taken. And this informs both decisions of the board of directors and also decisions of the general meeting. And it takes us back to discussions that we had in the past about how shares are primarily perceived as economic entitlements, financial entitlements, and not property rights. So we've got this tension all the time. Should we consider shares a property right, or should we consider them a financial entitlement? If you consider something a property right, you've got a closer link between the property and its owner. It's very difficult to expropriate property. But if you consider something a financial entitlement, what you're interested in is not the asset itself, but what it represents in terms of money. So if I were to take your laptop, you would have a problem with that, because this is your asset, this is your property, it's something that you're kind of more intimately connected with, like your laptop or your phone. But if I were to say the bank in which you have your bank account is closing, therefore you were transferring your bank account to a different bank, then you don't care if the money is the same, right? Or your electricity provider is shutting down, or they sold to somebody else and they're transferring over. You don't care. I mean, it happened to me. I was with, the electricity was provided by Co-op. Octopus was the one with the pink octopus, right? They bought the Co-op. So I received a letter that says, your account, your electricity supplier is now changing. Your account is getting transferred over to Octopus. And it said, of course, if you don't like it, because it's a change of contract, if you don't like it, you can leave altogether and go to somebody else. But the fact that they were changing over in the same terms and conditions, nothing was changing for me. I don't care. So long as the lights turn on when I click the switch, I don't really care who supplies the electricity, and the price is the same. Equally, if I have a bank account in NatWest or if I have a bank account in HSBC, so far as the rights attached to it are the same, I really don't care. But if they said, we're going to take away your phone and give you something of equivalent value, or your house, give you something of equivalent value, or your dog, you might feel differently about it. So they cannot, I mean, it's very weird that going from cases to cases, the courts cannot make up their minds as to whether shares should be property rights, that we should really keep them with their owners, or whether we should just consider them the equivalent of an amount of money. In all these discussions, how should we protect the rights of a minority, and are we allowed to kick them out if it's in the interest of the company? The position seems to be, this is money, who the hell cares? So the only thing that matters that comes out of all these cases is whether there's an independent and adequate valuation of the shares. So if it's independently valued, then you get the money, and it's like, that was the right thing to do, thank you for your service, goodbye. Actually, in the context of a merger, you got section 979 of the Companies Act that says if the acquiring party attains 90% of the shares, then they have the right to force everybody else to sell. This is something that's expressed in areas of property law as well, to be honest, because, this was 979 is the section. If somebody has purchased 90% of the shares, then they can, in a compulsory fashion, expropriate the rest of the 10. They don't expropriate, they compensate, but they buy the rest of the 10%. Because otherwise it would make the functioning of the company weird and uncomfortable if you had like a 10% complainer group stuck in there to kind of be as a wedge to every decision you're trying to make. If in the stock market, somebody is wishing to purchase the totality of the shares to take a company private, to take them out of the stock market, and they get they hit 90%, they can get the remaining 10%. And the people who've got that remaining 10% cannot object. So long as, of course, that they're compensated adequately. In the Twitter situation, Musk was actually paying above what was the market valuation of the company. So there was actually no reason to complain on the money. The only test that we've got that is checking this is whether the decisions are taken in good faith. So is the decision in the interests of the company? How can we tell? Because it's not the job of the court to kind of second guess decisions of the board of directors, but they kind of have to think were the decisions taken in good faith. So the only way you could challenge it is if you find that actually, you know what, they're not doing this because they think it's the best idea, but they're doing this because they hate me personally, because I challenge their policy, or, we have a personal thing going on, etc. Limited grounds, therefore, for somebody to resist decisions that are taken by the board or to resist decisions that are taken by the general meeting on the basis that they don't agree with the decisions. This isn't how company law has organized stuff. But what if they are actually out to get you? Derivative action is not going to help you here, because the derivative action wasn't they're out to get me. It was like they're doing bad things and damaging the company. So, either they're incompetent or they've got some sort of evil agenda that affects all the shareholders. What if they are actually out to get you? The mechanism for this is in section 994 of the Companies Act, and this is called unfair prejudice. So you're going to the court and you can complain that the company's affairs are being conducted in a manner that is unfairly prejudicial to the interests of the company generally, or to some of the shareholders, or just to you. And this can relate to things that the company has already done or things that the company is planning to do. You can do this and go to complain to the court for your personal protection. What sort of things are you going to complain about? If it was simply about violations of rights, so if you simply wanted to say this is a breach of directors' duties, etc., then you won't really need this, because you can always bring a derivative action. This is to protect expectations that you have that could either be expressed in the Articles of Association or in an external contractual document like a shareholders agreement, or, and this is significant, expectations that you had arising out of the relationship. So this is something that you can use to complain that your legitimate expectations are getting violated by what the company is trying to do. So that's why this is the unfair prejudice stuff is considered to be kind of wide-ranging and quite flexible, because you're saying they're after me because they don't like me or they're trying to mess up something, and now our understanding is that we're going to do this differently. And they kind of change the tables on me, which kind of messes up the whole reason why I'm here. It negates the value of my investment, or is kind of targeting me as an individual. So you've got the entire opportunity to do this using what is found in section 994. But you cannot simply use this to complain that they're losing you money. So you need, your legitimate expectations cannot simply be, I got into this to make money, these guys haven't paid dividends in 20 years, therefore what I'm doing here. That cannot be. Right? You need to find something that is targeted and is a violation either of an expressed right or a legitimate expectation. And if they're trying to kick you out, so if you're complaining against an attempt to expropriate you, this isn't enough just in and of itself, because if they're paying you good price for yourself, for your shares, the court will consider that they're treating you fairly. And again, it brings back to what I was saying earlier, that this sounds kind of weird that they're ganging up on you and they're trying to exclude you, but the court will be very much focused on the idea that you're getting fair value for your shares. So what sort of situations do we have that we can actually nail down what is unfairly prejudicial? Because it's nice to say it can be a bunch of stuff, but it would be good to know what we can have. If you look at cases like Saul v. Harrison, which is a case from 1995, the court said that the conduct being complained about must be both prejudicial, in the sense of causing prejudice or harm, and also unfair. So conduct may be unfair without being prejudicial, or prejudicial without being unfair, but we need both of them to be the case. Right? Okay, cool, but that doesn't actually give us any concrete examples. In O'Neill and Phillips, that is a case from 1999, again, they were talking about things along the same lines. Now, the best example is, of course, the majority taking away financial benefits. So if they're doing things that put you in a worse position, or if you have a class of shares and they're doing things that undermine the value of that class, that could be something to complain about. But the best example of unfair prejudice complaints, and actually the majority of the cases in the courts, is about people having started a business with somebody else, and at some point they get into a fight and they're getting kicked out. This is where all this is coming from. And remember that the vast majority of corporations are small outfits where a bunch of people come together, and the same people are the shareholders, the same people are the directors, and they're coming together to run their business through a corporate form. So let's say that there's three of us, and we've been working already, we have a shop together, we'll be working as sole traders or as contractors in close collaboration. We're thinking, let's incorporate, right, and do this in a more predictable organizational form, take advantage of tax advantages, issues of dealing with liability, and all the rest that we can have through a corporate entity. And we incorporate, and we are the shareholders, shareholding split three ways, and we're also three of us are directors. And at some point, we get into a disagreement. I want to move the business online. You don't. You want to keep the business, and the other guy want to keep the business physical. And you guys, because there's two of you and one on me, and you want to keep it that way, you decide to kick me out because we don't see the same way about the company anymore and the future of the company. Now, the way in which the unfair prejudice provisions in Section 9994 can help with this is that I can go to the court and say, I had a legitimate interest in continued participation in the way that this company is run. So I wasn't in it simply to be a shareholder and a director from time to time. I wanted to be a director for all time. And I wanted to be participant in the decisions and discussions about the future of the company. So if we started off in being positions of shareholders and directors, and because we disagreed, you guys kicked me off the board, I'm a shareholder, my money is still invested here. But now, because I'm not on the board, I don't participate in anything, and because you guys have got 2/3 majority, you can do anything you want with the company at general meeting as well. So I have now zero influence in what's going on, and I'm still stuck in the company. And this is unfairly prejudicial to me because this isn't what it was meant to be, and we create this company with another objective in mind. And the way this is expressed in the case law, these cases come under the label of quasi-partnership companies because they are companies, but in essence, they work like partnerships where all the people were supposed to be kind of in close collaboration with each other on what they do, right? So are we in agreement with this, that if there was three people that started to do something together and this was their livelihood, they didn't want to just be there as shareholders, they also wanted to be present in the board. So they wanted to be fully participant in running it, in deciding things, in distributing the benefits as shareholders when it came to it. So when they get into a fight and one of them is being excluded, the person being excluded, in fact, is losing something more than the technical rights to be a director if you get voted in. It's more fundamental what they're getting, and they're marginalized as a minority, and then they're left in a position that they're stuck. If that's what's going on, and you're successful in using this section to complain about it, what would you think is an appropriate solution? So what can we do for the person that's like the odd one out? I know, it sounds weird that the primary remedy for unfair prejudice is for you to leave the company, but it's the only rational solution. Because if people don't like each other, you cannot force them to work with each other anymore. It would be dysfunctional, and the company would not be successful. If they decided to part ways, what you can have is like a clean break, where they give you your money back and you go. Actually, not your money back. They give you whatever your investment represents right now, whatever the shares are valued at right now. And then you leave, and you can take your money and you can do something else with your life. So you're no longer stuck in this position of having no influence, but still having your money locked into this thing. On occasion, a remedy could be that the majority gets kicked out. Depending on what the facts are, it's also possible that the court is going to say, actually, you know what? The majority partners sell their stake to the minority if the minority is able to purchase it. And then the one person left carries out the company. If the company has become dysfunctional beyond repair, or the relationships are so damaged that the company would not be able to operate effectively, another possible remedy would be that they shut the company down. So the company is wound down and the money then is distributed to the people that were the participants. So there are all these options, that the minority person remains, that the minority person leaves, that the whole company is shut down. All of that is possible. The court will assess what is the most appropriate response in the circumstances. But the important thing to remember, and we'll finish with this, at least this part of the presentation, is think of shares as money, as financial entitlements more than property rights. And when it comes to things falling apart and people in a minority position feeling that they're in trouble, there are various ways that you can deal with this, both in the way that you organize the relationship on the way in that can help you, but on the way out, there is ultimately the ability to complain for unfair prejudice, and this again gives you a range of options. This is very contentious. People get into fights, relationships break down, people end up in the courts about it. It's something that generates like lively jurisprudence. And even though we have clarity now, better than we used to, on what the law is and what are the technical steps to complain for unfair prejudice, it's still something that gets debated even on the point of the law. Sometimes you got cases like this that it's the higher courts that they talk about it. So it's an interesting area that can generate both kind of theoretical questions about how the law is evolving and practical questions as to how do you advise somebody who's in a minority position.
Thank you for listening till the end, and visit the rest of the Whole Law Series playlist for more lectures on key English law topics. See you next time.